Let's start. Learned advocate representing the private respondent submits that as the petitioner is a non-resident Indian, accordingly he executed a power of attorney in favor of his brother who stays at the subject premises. It was the duty of the power of attorney holder to proceed with the matter with due diligence and not delay in approaching the forum within due time. Para. It has been submitted that the private respondent has already demolished the unauthorized portion at the top floor of the subject premises. The special officer within bracket building permitted retention and there is no reason to interfere with the same. The respondent's plea for dismissal of the writ petition. Para. I have heard and considered the rival submissions made on behalf of all the parties. Para. It appears that the petitioner initially raised the issue of unauthorized construction in 2013. He addressed repeated representation to KMC seeking demolition of the unauthorized construction. He approached this court by filing writ petition in the year 2017. But in the meantime, the special officer within bracket building in the year 2014 concluded the demolition proceeding allegedly initiated suo motu under section 400 of the KMC Act 1980 and permitted the person responsible to retain the construction made subject to the conditions mentioned in the order. Para. Any order passed under section 400 is appealable before the appellate forum. The appeal is to be filed within a period of 30 days from the date of the order. The petitioner, instead of approaching the appellate forum, filed writ petition before this court challenging the retention order for the same reason. The writ court disposed of the writ petition by granting liberty to the petitioner to prefer appeal before the appellate authority. Para. The court, after noticing that the time limit for preferring appeal expired, gave liberty to the petitioner to file the same within a fortnight from the date of the order, and if the same is filed within the aforesaid time limit, then the appellate authority was requested to consider such appeal, treating the same to be filed within the period of limitation. The same implies that the court condoned the delay in preparing the appeal, provided the same is filed within a fortnight from 26 June 2018. The petitioner ought to have approached the appellate court within the stipulated time and availed the opportunity granted by the High Court. Para. The petitioner was, however, advised to prepare review of the order dated 22nd June 2018. The said application for review was rightly dismissed by order dated 31st August 2018, but by that time the leeway granted by the court to prepare appeal stood lapsed. Para. The petitioner claims that he was advised to prepare an appeal from the order passed in the review petition. The said appeal also stood dismissed on 2nd July 2019. The petitioner ought to have sought for extension of time before the Honorable Division Bench to refer the appeal before the appellate forum, but it appears that the same was not played for. The petitioner ultimately preferred appeal before the Municipal Building Tribunal on 7th June 2022, but the time limit prescribed by the court for preferring appeal long expired. The tribunal, on pursuing the order passed by this court, refused to admit the appeal, and hence the present writ petition has been filed. Para. Learned advocate for the petitioner tries to impress the court by submitting that the order of retention passed by the special officer is bad in law and on facts, and As such, the same is liable to be set aside irrespective of the fact that there has been delay in approaching the appellate authority. The delay that has been caused is absolutely unintentional and beyond the control of the petitioner. Mere technicalities ought not to stand in the way of proper dispensation of justice. The special officer recorded that there was no complaint from any neighbor with regard to the construction in question. Admittedly, the petitioner raised objection against such unauthorized construction, but for some reason or the other, the objection of the petitioner was overlooked, noticing that there was no objection against such unauthorized construction and that the construction was not hampering the interest of anybody. The prayer of the person responsible seeking retention of the impugned unauthorized structure stood allowed, however, subject to payment of necessary retention charges. There may have been genuine reasons for the petitioner to be aggrieved by the order of retention passed by the special officer, and as such the petitioner ought to have approached the appellate forum on time, even though the petitioner got the opportunity to prepare the appeal before the appellate forum within the extended period of limitation. But it appears that the petitioner failed to avail the said opportunity and in fact lost the opportunity to approach the appellate forum. The petitioner, possibly on wrong advice, delayed in approaching the appellate authority and tried to pursue remedy before the Constitutional Court as the statute prescribes an appellate forum. Accordingly, a party aggrieved by the order passed by the authority ought to have availed the said remedy rather than file one after another petition before the High Court. By this way, the petitioner not only lost the scope to prepare appeal, but also lost valuable time and money, which is irreparable. The petitioner would argue that a litigant ought not to suffer for the erroneous advice of the advocate. True, it is, but the intervening events stand in the way to grant relief in favor of the petitioner by applying such principle. The demolition proceeding culminated in an order of retention. The order of retention was conditional, subject to fulfillment of certain conditions. The persons responsible have already complied with the conditions set forth in the retention order. The unauthorized room in the top floor of the subject structure has also been demolished during the course of the instant writ petition. Due to passage of considerable period of time, that is more than 9 long years, a valuable right has accrued in favor of the persons who sought for retention. There may be persons who is oblique are enjoying the said portion which has been permitted to be retained for close to a decade. Admitting the appeal at this stage will put the settled position to jeopardy. Will it not be improper to reopen the issue all over again when the matter was put to rest so many years ago? Law prescribes a period of limitation only to reach a proceeding to its logical conclusion. A proceeding cannot be permitted to continue for years together. Litigation has to end somewhere. A litigant ought not to wait for eternity to know the fate of a legal proceeding, and at the same time, a litigant who obtains an order from the court is entitled to reap the benefits of the same. The ratio laid down in Deepak Kumar Mukherjee within bracket Supra is well settled, but in the instant case the private respondents were able to get the unauthorized construction regularized from the competent authority long back. Once the unauthorized portion is permitted to be retained, the same cannot be treated as an unauthorized one. The facts taken into consideration at the time of regularizing the unauthorized construction may not be proper or correct, but it was for the petitioner to point out the discrepancy in facts at the proper time. Had the petitioner been genuinely aggrieved by the order of retention, then prompt steps ought to have been taken to challenge the same. The order of retention passed in the year 2014 was challenged for the first time in 2018. That too not before the statutory forum. The opportunity provided by the court by condoning the delay and extending the period of limitation by taking the liberal approach principle as in collector land acquisition. Anantnag within bracket Supra should have been taken advantage of. Stop pair. The plea that the petitioner is a non-resident Indian as in East Coast Ispat within bracket Supra cannot come to the aid of the petitioner in the instant case, as the petitioner already executed power of attorney in favor of his brother who stays at the subject premises. On execution of the power of attorney, it is the duty of the attorney holder to deal with the legal proceeding in a proper manner and not delay the same to such extent that seeking remedy becomes impossible. Pandemic as in Sebastian Chocatus within bracket Supra can certainly not be a ground in this case to condone the delay. Reopening the issue at such a delayed point of time will not only cause prejudice to the private respondents but will be sheer injustice to them, extending substantial justice to the petitioner as in Balakrishnan within bracket Supra should not result in causing injustice to somebody else. Once a time limit has been framed by the court, it is the duty of the litigant to act within the said time frame. If for any reason the time limit fixed by the court cannot be adhered to, then it is the duty of the litigant to seek extension of time for acting in accordance with the said order till the time limit is extended by the court. Then any act done beyond the fixed time frame becomes barred by the principle of limitation. Admitting the appeal filed beyond the extended time period would be acting contrary to the order passed by this court. The delay may be because of incorrect legal advice and may not be intentional or deliberate, but the said erroneous delay is fatal in the facts and circumstances of the instant case. There is hardly any scope to put the clock back for revisiting the issue all over again. The chapter of illegal construction has to be taken as a closed para. The tribunal rightly refused to admit the appeal. The court does not find any reason to interfere with the order passed by the building tribunal para. No relief can be granted to the petitioner. Writ petition stands dismissed. There shall, however, be no order as to costs para. Urgent certified photocopy of this judgment, if applied for, be supplied to the parties or their advocates on record expeditiously on compliance of usual legal formalities. Stop. Thank you. Jai Hind. Jai Mera Bharat.